My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the Schrems II decision and the Cloud Act. As a result of the Schrems II decision, the privacy shield between the US and the EU was invalidated. Prior to the privacy shield, the EU and the US had an agreement called a Safe Harbor Agreement, and that was invalidated in 2015. That had gone on for 15 years before the Privacy Shield. Now that the Privacy Shield between the EU and the US has been invalidated, people are scrambling to look for alternate means of data transfer from the US to the EU. Many companies are relying on, if they already have them in place, binding corporate rules, standard contract clauses, and also making sure that they can have adequate additional safeguards. It's still up in the air as to if those things would be amenable to certain countries. For example, as a result of the Privacy Shield invalidation, Germany said that they think that companies should immediately stop data transfers and possibly repatriate their data back to Germany. So it's very interesting to see how this definitely plays out. However, one wrinkle in a possible negotiation for maybe a second privacy shield is the Cloud Act, which was passed in 2018. So in 2018, the U.S. government passed a law saying that companies that are U.S. based, even if they have data overseas in different countries, for law enforcement or national security purposes, if they are asked to turn over data about an individual, they can be compelled to do so, even if the data is in another country. So the purpose of this law was to try to get businesses out of the middle of situations where country to country needs to make some type of negotiation. So also part of the Cloud Act is if the company gives over the data to the U.S., the U.S. has to work with that country to, using the executive branch in some way, shape, or form, to negotiate that transfer so it's not seen as being an illegal transfer by the company. When the Cloud Act came out, and probably still today, a lot of companies and a lot of my clients in the EU have been very up in arms about the Cloud Act. And as a result of the Privacy Shield invalidation, I feel that it's going to make it much more difficult to come to some type of arrangement to replace the Privacy Shield, especially with this law in place. As we know, the Privacy Shield basically has taken away a method in which data can be legally transferred to the U.S. Because the U.S. now is considered inadequate. So some of the things that companies are doing, in addition to possibly not transferring data to the U.S., they're either transferring less data, they're stopping transfers, or they're really heavily relying on standard contract clauses and making sure that in addition to those clauses that they're adding what they deem adequate safeguards between the controller and processor role. Also, this puts more highlights on countries that have adequate protection, like Canada, Switzerland, Jersey, the Isle of Man, Israel, things like that. So it remains to be seen what's going to happen. I'm curious to see what's going to happen. I think if the EU and the US strike a deal, like a Privacy Shield 3, I think it may be a long time coming, or it will be not sure how strong it's going to be in terms of being able to reconcile things like indiscriminate data processing or data capture, surveillance, and definitely the Cloud Act. That's it. Thank you. Bye.